I'm going to cover what has become the never-ending saga of the rest of meal breaks. The Brinker case, as some of you, I'm sure most of you are aware of, was a very significant decision by the California Supreme Court. For those of you that aren't familiar with what really that case involved, it resulted from a Court of Appeals decision that was in the matter of Brinker Restaurant Corporation. That was the party's name. Brinker owns Chili's and other restaurant chains. And they had been sued by a class of employees for missed meal breaks and missed rest breaks. And the Brinker case, when the Court of Appeal made its decision, the Supreme Court took that decision, granted cert, and they said they were going to evaluate and rule on what the requirements were for rest breaks, what the requirements were for meal breaks, and then also what the requirements were for class certification in these kinds of cases. I'm going to focus on the meal break requirements and rest break requirements, and I'll just touch on what the class issue was just so you're aware of it. But I imagine that most of you probably, unless you have the misfortune of having to deal with a class action, probably are less interested in the class. The meal break requirements. Here's what did not change. You as an employer still have an obligation to make sure that if you have an employee that's working for you, you have an obligation to allow that employee to take 30 minutes time off, uninterrupted, off duty, to have a meal. And it must happen before the end of the 5th hour of work. That's the basic requirement. And then, of course, if the person's working a long shift, they get a second break before the end of the 10th hour of work. Okay, so then what did change? Timing was a big issue. For those of you that maybe didn't have the misfortune of having to deal with this particular issue when this clarification was not put in place, it was a nightmare. There was an enforcement position taken by the Department of Labor Standards Enforcement that said it had to be taken at a particular time. And if you had your employees clock out early to take a lunch break, then you could be in trouble. So, and that's where Brinker that's why they took hold of this issue. That restaurant chain had a habit of wanting their employees to take their meal breaks at the beginning of their shift. So they'd clock in, they'd work maybe an hour, and then they'd be taking their meal break. And the reason they did that was because once the restaurant got busy, it was very hard to relieve the servers to go take their meal break in the middle of a shift. And frankly, I have represented a bunch of restaurants, and we find the employees don't want to take their break at the time that closer to the 5th hour. And we'll typically skip it because they don't want to leave their tables and not get the tips. So what Brinker, the Supreme Court, what they decided in Brinker was that the statute says no later than the end of the 5th hour worked. That's the fundamental requirement that you must comply with. They don't say that they don't say the statute encourages and allows it any time you want, but they do say there is some flexibility, that early lunches are okay. But I would say, after reading the decision, that the court is saying if there's really a reason for that, if you can show that there's something about your workplace that makes it more optimal for people to take early lunch breaks, you can do that. But the optimal is more towards the middle of their shift. And the other issue in Brinker that was in question was the timing of the break. So if someone took an early lunch break early in their shift, then the question was, does that impact the timing of the second break? In other words, does it create kind of like this rolling trigger? If someone took their meal break at 10 o'clock in the morning rather than noon, does that advance the time of the second break? And the Supreme Court said no. The only requirement is before the end of the 5th hour worked and before the end of the 10th hour worked. So if someone takes a break very early in their shift, you don't have to make sure they take an earlier second break, just as long as it's before the 10th hour. So next, the penalty. What did not change? You still are liable for 1 hour premium pay if you fail to provide your employees with the opportunity to take the meal break, as I just described. that is something that became a big issue about whether the penalty was going to be affected by the decision. It really is not affected by the decision in a significant way. That rule remains. If you don't provide your employees with the opportunity to take a break as the statute requires, you're still liable for that penalty. And you're also, and this is really important, you're also still responsible for maintaining accurate records that reflect all the hours your employees worked, including the start and the end time of their meal break. What changed was, back before the Brinker decision came out, if an employee, if you had a policy that provided for someone to take a meal break and the person skipped their break, then you were automatically liable. According to the DLSC, that's how they enforced it. They said that the law should be interpreted to say you not only had to provide it, but you had to ensure it. That's really fundamentally the big change that the Supreme Court brought to bear on this issue, is they clarified that they interpreted it to say, no, that it doesn't mean you have to ensure, it just means you have to provide. So if you have a policy and you allow your employees the opportunity and that person skips their break for their own personal reasons, well, then you're not liable for that one extra hour. But here's the thing. I don't see a lot of change to the growing trend of these kinds of cases, and I would venture to guess neither has Dave, just because of this change. Because it doesn't give you immunity just because you have a policy in your handbook. Start there. You want to have a policy in your handbook that says what the law requires, but you also want to make sure that there's nothing about your work environment that makes it impossible for or causes people not to be able to take their breaks according to that policy. And I'll give you 2 examples of where that happens, and sometimes inadvertently. One way you could be responsible, even though you think you're providing breaks for all your employees, but someone makes a claim and says that they're entitled to penalties because they couldn't take their break, is because you have other people working for you, managers, who maybe misunderstand these requirements, or worse, discourage people from taking them. So I am aware of a case where someone actually said something to some laborers that were taking their break, their 10-minute break. What are you doing? Well, we're taking our 10-minute break. You're not really supposed to take a break. And indicated that was really just a policy that was in place that was a formality, but not really. Nobody but wimps took their actual breaks. The other way it comes into play, and again, almost without people knowing it, is when you don't know necessarily, you're not aware that the work schedule that your employees are having to follow really makes it impossible for them to follow your policy for breaks. So you may have a list of clients, like a schedule of clients that your employees are expected to accomplish in a day. And I've had that situation where the employees were able to prove that there was no conceivable way they could do what was expected on their list of things to do and still take their breaks. And the employer's response was, well, that's a guideline. I don't expect them to actually, every day, come hell or high water, they get all those things done. But the employees took the position that that's what the paper says. The schedule makes that clear that that's what we're expected to do, and we were skipping our breaks to do it. So you want to make sure you have a clear break policy and that nothing actually, as a practical matter, prevents your employees from following that policy. Okay, so rest breaks. What did not change? Again, the basic requirements for providing rest breaks did not change because of Brinker. So you still have to authorize and permit your employees to take at least 10 minutes for every 3 hours work, so 3.5 hours work. 10 minutes is supposed to be sometime between the 3.5 and 6 hour time period, and the second break sometime between 6 and 10. And what did change? The timing of the rest break got some clarity from the Brinker decision. So what the Supreme Court said was middle of each work period is considered to be in a typical 8-hour workday as a general matter. It means, ideally, you want to give your employees 10 minutes before the meal period and 10 minutes after the meal period. That, as a general rule, is how the Supreme Court interpreted the rest period requirement. There's no absolute obligation, though. And again, this was the issue that was one of the major issues that prompted this litigation. Was the DLSE was taking the position that that was absolute. You had to have it spaced that way. And the Supreme Court said, no, there are situations where the industry or the type of business could justify some alternative arrangement. I would tell you not to want to be the test case. My suggestion is follow that. If you really can do it, there's nothing stopping you. Don't vary from it. This is the ideal. So you want, if you ever get questioned about your rest breaks, you want to be able to show, no, our policy is we tell people, first 4 hours, find a time in the middle of the shift and take your break, or just schedule it, and then have a meal, and then have the second one in the afternoon. Don't try to be real innovative with your scheduling if you don't have to. But of course, if you have to, the Brinker decision gives you some support for that variation. Before I move on, I just want to mention, for those of you that aren't aware, that there was a clarification with respect to the penalties, not last year, but the year before. If you miss a rest break, if someone misses a rest break and they also miss a meal period, there used to be an argument that we lawyers would make about there only really was one premium owed based on the way the law was written. And unfortunately, one of the courts of appeal in 2011 said no. If you have someone misses a rest period and a meal period, you owe 2 extra hours.